may be a hot afternoon, Mr. Cuddigan, so within the bounds of decency, if you want to remove garments, please do.
Very great. We'll take you up on that offer. Arnold, we were in paragraph 572 of the judgment.
Yes.
I don't think we need to turn it back up. We don't have it in front of us. My quarrel with the learned judge is that he was saying you can use differential profits where it's clear that all the profits can be attributed solely to the infringement. To which we say, well, that's the whole point of the analysis. They have been attributed to the infringement because that's the effect of the differential profits analysis. And furthermore, in the context of Astronics, their own economic expert accepted as much. I'm running a little behind time, so I hope you'll forgive me if I just give you the transcript references. This is supplemental bundle, tab 12, page 119. Transcript page 40, lines 7 to 25. Mr. Bazant accepted that as a matter of economics, differential profits and apportionment were alternative approaches to the same problem. And then page 42, line 12 to page 44, line 8, he accepted that in relation to Astronics, there wasn't a problem with effecting a clean isolation. In other words, differential profits have done its job. So he took a different view to the judge. I wanted then to specifically address one of the points that goes against us about complex products. And we'll see a bit more of this when we come on to the Neo case, because the judge was of the view that a different legal approach was to be applied to what he called complex products. And this is a point that my learned friends also take up in their skeleton. At this juncture, we have 4 points to make. First, we say the authorities all run against them. What is really meant by complex product is a product where there are multiple profit drivers. But almost without exception, commercial products have multiple profit drivers. Even taking the simple example that my Lord Justice Lewison put to me, a patent for a widget, even if an infringer's widget has no other functions, matters such as brand association, marketing, after sales, reliability, those all contribute to profitability. Moreover, every trademark case is a complex product case. The goods have their own intrinsic value, and the value of the trademark is distinct from that. And yet, Lord Leggett was clear in Lifestyle Equities that an analysis of the counterfactual may lead to a finding that there would be no sales of clothing without the trademark. Similarly, in Rukadze, there were multiple causes for the defendant's profit. They used their own professional skills and knowledge to provide the services. They used their interpersonal skills to maintain an independent relationship with the family. These are all equivalent to the non-wrongful value-added contributions that Astronics rely on: certification compliance, weight, power conversion technology, and so on. That is why the Rukadze defendants were able to assert that if they'd resigned earlier, they would still have provided the recovery service and made the same profits. That's a complex profit pool with multiple causes, not conceptually different from a complex product with patented and unpatented features. And Lord Leggett's answer was not to apportion between the defendant's skill and the disloyalty. It was to ask, what would have happened in the correct counterfactual? No use of the restricted information. That would have yielded no profit whatsoever, so none was deductible. Second, we say that the efficacy of differential profits is not diminished in the face of this complexity. When a patent covers part of a complex product and substitute parts are available to the infringer, like in the example of Mr. Justice Laddon, that the infringer can rely on notional trade using those substitute parts, and the resulting profit award would be reduced accordingly. If they had particular expertise in marketing, that can be relied on in support of the notional non-infringing trade. But if the patent controls the market for the whole complex product, the only way to give full effect to the conduct-based monopoly is to awarding the profits. The extent of control is demonstrated by the counterfactual NIA analysis. And third, we rely on extensive academic writing in support of our position. This is set out in paragraphs 15 to 17 of our reply skeleton. One of those citations is a textbook which is dedicated to the complex product problem. It is called Patent Remedies and Complex Products. It was written by 20 international legal scholars, and their specific recommendation for dealing with accounts of profits for complex products is to deploy differential profits alone. For my Lord's note, that's JA4, tab 95, page 3267. Fourth and lastly, given that it is accepted that even for complex products, an award of all profits is an available outcome, this point really devolves to a question what the test should be for achieving that outcome. Astronics say the test is one of driving the sale, paragraphs 27 and 28 of their responsive skeleton. As we saw earlier, Lord Leggett equated that test to the counterfactual non-infringing alternative analysis in lifestyle equities. A sale will be driven by the infringement where the customer insisted on the patented product, so that there is no non-infringing alternative for that customer. We say that is conceptually coherent because the differential profits test is directly linked to the conduct-based monopoly issue. The last point I need to address on ground one is Astronics' argument that because their NIA case was rejected, the differential profits analysis had failed and another isolation approach was justified. The argument involves a fundamental misunderstanding of what is involved. As I've already mentioned, the party in breach always has an NIA. The base NIA is simply not doing the acts of infringement, not carrying out the infringing trade. Under the differential profits approach, the party in breach is permitted to try to prove a different active course and rely on the associated profitability. In the present case, Astronics' active NIA was held to be an infringement. So the NIA they were left with was simply not trading in mains voltage power supply for aircraft. They say that involves the failure of the differential profits analysis, but we disagree. Differential profits allows for a nuanced award of anywhere between 0% and 100% of profits, according to the control of the market exerted by the patent. If Astronics had asserted their USB power supply, low voltage DC, as an NIA, the judge might have held that that would have made a handful of the sales in issue and awarded 98% of the profits. Can't be in a better position, having failed in their attempts to argue that they could have reached the AC power market at the same time as avoiding the patent. And once again, Astronics' position is closely analogous to that of the defendants in Lufthansa. Those defendants asserted an NIA which involved resigning earlier than they had in fact done, and then exploiting the business opportunity and information that was rightly controlled by the claimant. Lord Legate held that active NIA was still a breach of their fiduciary duties and still using the information in issue. So just like Astronics, the NIA they asserted was an active breach. He didn't then just throw the analysis out and say, well, this is a failure, so we need to do something else. Instead, he considered the legitimate non-infringing alternative, resigning earlier and not using the information that was protected. And that NIA resulted in the accrual of 0 profits. So that is the appropriate deduction. This is the direct equivalent of Astronics declining to sell 1171 power supplies in the UK. They accrue 0 profits in any other situation, and that is the right and proper deduction. There are 2 authorities Astronics rely on for this point. First, the descendant judgment of Justice Cote in Nova and Dow. As to that, they say there is no reason to assume it was not a correct statement of the law in Canada. It's a very good reason, because it conflicts with the majority judgment given by Justice Rowe, who states at paragraph 3 that the first instance judge found that because there were no relevant non-infringing options, Justice Rowe found that because there were no relevant non-infringing options, the trial judge, quote, fairly determined that all of Nova's profits were causally attributed to Dow's invention. That's JA 4 tab 90, page 2991. And the last, or the second authority, is an article by Professor Seabrass.
Dow and Nova, the patent was for a particular type of plastic.
Yes.
And the argument that the infringer put forward was, well, if I hadn't sold this plastic, I would have sold something completely different.
Yes.
And the hypothetical profits I would have made from marketing that hypothetical product should be deducted. And that was the argument the Supreme Court of Canada considered. And it's not entirely surprising that they rejected it.
Well, it's a sort of, it has generated some controversy, that, because according to a strict but-for comparison, if you succeeded in proving that you'd have done something else, so for example, you could say, I would have bought Bitcoin. If I hadn't gone into infringing power supplies, Astronics would have bought Bitcoin, and look at all this money I'd have made, that it should be deducted. Some legal scholars say, well, that's correct. If you can persuade the court that as a matter of fact that is the course you would have adopted, then it's a legitimate deduction. The Supreme Court in Canada said no to it because it fell outside the purpose for which the differential profits was being deployed, to isolate the infringement-flavoured profits. It's being used as a causation tool, and the Bitcoin investment is nothing to do with that objective. As to the Professor Seabrass article, firstly, he didn't have the benefit of Nova and Dow, but more significantly, he was not considering a situation where the court has determined as a fact that the patent acted as a complete market barrier to the defendant. My lords, I was going to move on then to ground 2, which is concerned with legal causation remotely. And our appeal here rests on the following 4 propositions. First, patent infringement is a statutory tort which is conduct-based. One can only infringe a patent by carrying out infringing acts. Second, Section 61 provides remedies in relation to acts of infringement. The financial remedies are expressed as damages in respect of the infringement and profits derived from the infringement. But these are remedies in respect of infringing acts. That does not appear to be accepted by scholars. Third, in order to recover damages or profits, a patentee must establish factual and legal causation. So infringing acts must be proved to be the factual cause of damages or profits, and the same infringing acts must be proved to be the legal cause of damages or profits. So legal causation is a filter which is applied to the link between the tortious act and the financial consequences. Fourth, the decision of this court in NEO did not change the legal causation test. Different language has been used to describe that test: a common sense cause, approximate cause, an effective or substantial cause. What is critical for present purposes is the indefinite article. It is explicit in whatever language is used that legal causation can be satisfied when the tort is one of a plurality of causes. The test is not one of dominance or preeminence. The judgment under appeal conflicts with these points in three key respects. First, the approach to legal causation is detached from any infringing acts. Second, instead of a proximate cause, it substitutes a test of the real driver, a dominance test. And thirdly, it anticipates that damages or profits can be recovered when they are not legally caused by a defendant's infringements. So the consequence of failing on remoteness is you still get damages or profits. There is a nexus between these last two errors. The judge applied too stringent a test to legal causation, the real driver, but then declined to accompany it with the proper consequences, which would be irrecoverability. Instead, he allowed, in effect, a reasonable royalty allocated profit. He relied on Anand Kasai and NEO to justify his approach. So can we please turn to that decision now? This is Authorities Bundle 3 at tab 69. We're going to spend a little time with this, so my apologies to my Lord Justice Arnold, who's very familiar with it. We need to take some care because Astronics has, in their skeleton, misunderstood the facts of this case in a critical way. So can we start, please, by reviewing then that this is paragraphs 8 to 14 and 26. Perhaps I can summarise. The position was this: that the patentee Rhodia and the defendant NEO both manufactured a compound called cerium oxide. They both competed to sell it to Johnson Matthey, that's JM, who used it as one of several ingredients in vehicle catalysts, catalytic converters. Rhodia had a UK patent for this cerium oxide, but no relevant patent protection overseas. JM had their main test facilities in the UK, but it manufactured commercial product, catalysts, in South Africa and Macedonia. NEO's product was all made in China, and NEO was held to infringe by making initial supplies of cerium oxide to JM in the UK for the purposes of testing. And these started with very small, free of charge samples which were tested in the JM lab, and then some larger consignments which JM paid for, which were used to make prototype catalysts. So the original test was just of the cerium. They got the green light, they got more product in, they made actual catalysts. They tested the catalysts, and so did the ultimate customers, which was the car companies. Car companies ran fleet trials on the catalyst and analysed their performance. And the idea was that if all these various tests were successful, then cerium oxide would be qualified for particular vehicle platforms, with large commercial orders from JM's overseas factories would follow. But those orders would be would be made to Neo in China. They'd be satisfied by production in China that was supplied overseas, never touched the UK. By the date of trial, Neo was a quite convoluted foreign lost profit damages claim. But Rhodia's first head of claim was a conventional UK lost profit damages claim. And this sheds some light on the judgment. So the damage asserted by Rhodia for everything was found in the sales to JM, which they said they had missed out on. So JM buys cerium from Neo instead, and Rhodia says we've lost sales. And for the first head of claim, they said we've lost sales of cerium oxide in the UK as a result of Neo's sale of cerium oxide in the UK. So that the disposal of cerium by Neo in the UK was an infringing act. The infringing act was itself a transaction generating revenue for Neo. The only remaining question was whether Neo's sale of cerium oxide had displaced what would otherwise have been Rhodia's sale of cerium oxide. So you might see there was one degree of separation in that chain of causation. Straightforward and conventional, and it settled almost as soon as it was pleaded, as you can see from page 2065, paragraph 3 of the judgment. So the UK claim settled for £85,000, and that reflects the very small quantities that actually came into the UK. All the significant shipments went from China to South Africa or China to Macedonia. Now, those overseas supplies to JM were said to displace overseas supplies by Rhodia. But the overseas disposals were not acts of infringement, not of the UK patent or of any patent. So Rhodia's challenge was to link their own displaced overseas supplies to Neo's original UK infringing acts. And it was the length of that link which raised legal causation issues. So if you start at the beginning, the causal chain asserted by Rhodia, and you can see this from, it's cited within paragraph 28 of the judgment, page 2072. The causal chain was as follows. First, Neo disposes of product to JM in the UK. That's an infringing act.
Sorry, which paragraph?
The embedded quote at paragraph 28.
28.
So I'm paraphrasing, I'm pulling out the steps in the chain, the links in the chain from my notes. So the disposal in the UK is number one, that's an infringing act. Second, that cerium oxide was tested by JM and had to be approved on a substance basis if the project was to go forward. That involved no act by Neo. Third, if the test was successful, the cerium oxide was made into catalysts by JM. Again, no act by Neo. Fourth, the catalysts were tested by JM and by car makers. The car makers were assessing the performance of the whole catalyst, for which the cerium oxide was just one ingredient. No act by Neo. Fifth, car makers would then give approval in relation to particular car platforms. What actually happened was that Neo qualified for supply of cerium oxide for 4 car platforms, and Rhodia was also qualified on those platforms, so there was direct competition between the two. 6, JM places orders with Neo. The evidence was that JM would choose between Neo and Rhodia on the basis of price and availability. Again, no infringing act by Neo. And only now do we come to the acts which read on to the dispute in our case. 7th, Neo supplies cerium oxide to JM in South Africa and Macedonia. That was the equivalent to the power supplies in the UK. But it wasn't an infringing act in the Neo case, because manufacturer was in China and supply was outside the jurisdiction. Eighth, those acts of overseas supply by Neo were said to have displaced Rhodia's own sales. So unlike the claim for UK commercial supplies, the claim relating to overseas supplies, there were multiple non-infringing decision points and up to several years between the UK infringing act and the foreign commercial sales. Now, one could argue about the significance of each of these steps, but we would suggest that there are effectively 5 degrees of separation here, 5 links in the chain between the infringing act by Neo and the loss of a sale by Rhodia. Factual causation was admitted by the time of the appeal, so was foreseeability, but the judge held that the upshot of all these chain links that legal causation was not established. The lost profits of Rhodia were too remote from Neo's acts of infringement. And although the context was this elongated causal chain, it's clear that Neo contains an entirely conventional application of the test for legal causation, as per Gerber and Lecture of Q8 Airways, and as explained in Manchester Building Societies and Grant Thornton. We can see what's in issue from Neo at page 2090, at paragraph 95. Just picking it up in the middle of that paragraph, but Neo maintained that the damages claimed are too remote in the broader sense that the losses were not legally caused by the infringing acts, because those acts were not a sufficiently effective or substantial or proximate cause of the losses. And then paragraph 99, second sentence, Neo do not dispute that it is sufficient for the infringement to be a rather than the cause of the loss. The question is then whether the judge applied the correct test. 2 points to note here. First, the debate acknowledges that there's a critical difference between the use of the indefinite and definite article, because the definite article carries with it a requirement for preeminence or dominance which is not justified. And second, it was common ground that the definite article was wrong in law. Both points are confirmed by paragraph 100. The last sentence. Rhodia's complaint was that the judge had erred in applying a definite article test, requiring them to satisfy the higher threshold of proving the common sense or proximate cause of the losses claimed. And at 101, that complaint is dismissed for 2 reasons. First, because although the judge's language was not entirely consistent, it was clear that she'd not required the infringing acts to be the sole or dominant cause. And the second reason is a helpful illustration of the point. Secondly, Neo say that the logic of the judge's analysis confirms this. She did not stop her analysis as soon as she found other causes of the losses, but on the contrary proceeded to an evaluation of whether the infringing acts were sufficiently proximate to the losses. I agree. So that confirms that the test promulgated is not one of dominance. One is simply looking for a proximate cause. So that begs the question, what was Neo doing when it used the language of drivers to discuss legal causation? The driver language is introduced at the end of paragraph 102. And in the middle of 102, my Lord Justice Arnold says this: thus it is common ground that the fact that an infringing act creates an opportunity to make a non-infringing sale does not mean that the former is legally a cause of the latter. Now, pausing there, note please that that latter is not an incident of Rhodia loss. It is an interstitial event, Neo's non-infringing overseas sale. And the passage goes on. It is necessary to consider whether the infringing act is a sufficient driver of the non-infringing sale, that it may be regarded as a proximate cause. We suggest that in context, this is a reference to a proximate cause of the losses claimed, as discussed at the end of paragraph 100. What we read my lord as saying is that one must investigate the causal influence of the infringing act to see whether the link to the claimed loss is sufficiently strong to permit recovery. And within that overall investigation, the driver language in paragraph 102 is being used specifically in relation to a shorter section of the chain, the link between the infringing act and Leo's overseas sale. And it's this same foreshortened chain which is under review in paragraph 116, which is the paragraph on which Mr. Justice Leach places so much weight. But in paragraph 116, the analysis starts at the other end of the chain. Rather than focusing on the infringing act, here the judgment focuses on the non-infringing overseas sales and looks at the factors which motivated them. Again, that's not the very end of the chain, because that would be Rhodio's displaced sales, but it is right next to them. So if we just move back to paragraph 113, in the fourth line, which it's explained that Neo's sales depended not only on JM's choice, but on the decisions of the car makers as to which catalyst system to purchase, and that depended on the performance of the catalyst system as a whole, where the Neo component only played a part. Then at 115, beginning, we're told that the judge made no finding that the car maker's decisions were driven by the performance of the cerium oxide component. Now, in that context, could you please read to yourselves paragraph 116? This passage refers to the following causal considerations: JM's requirements, performance of the cerium oxide, the decisions of the car makers, the performance of other catalyst components, and the performance of the whole catalyst system. Those are factors in the various purchasing decisions by JM which led to non-infringing overseas sales. They are relevant because they show why the UK infringing acts, way back in the mists of time, were not sufficiently proximate to Rhodio's claimed lost profit damages. But none of these factors is being itself reviewed by reference to the approximate cause test, because none of this is addressing infringing acts.
But on your argument, wouldn't it be the case that Neo's supply overseas of cerium oxide to JM was not an infringing product at all?
It wasn't an infringing product.
So when my lord uses the phrase non-infringing alternative, on your argument, that is simply not an appropriate phrase to use.
Which paragraph do you have in mind?
116. Neo's inability to satisfy them with a non-infringing alternative. Your argument is that nothing that's happening overseas in shipping the stuff from China to South Africa or Macedonia is infringing. So it is a non-infringing alternative.
My lord, that is a callback to an earlier part of the judgment and the decision on factual causation, because at trial, Neo had asserted we could have made a different cerium oxide which was non-infringing, and it failed. So that is what that passage is calling back to. From memory, I think it's paragraph 50 of the judgment. Yes, it is.
50.
Yes.
Yeah.
None of the factors here is talking about proximate cause because none is addressing infringing acts. The supply of the original test samples is not even mentioned in this paragraph. The last factor, the performance of the whole catalyst, is said to be the real driver. But that finding is not the application of the test for legal causation, or indeed any other legal test. It's simply a conclusion on the facts, which forms part of the reasoning on the way to the legal causation conclusion. So I've got 4 reasons why that's clearly not the application of the legal causation test. First, it would be contrary to all the legal analysis we've looked at, substituting a test of dominance in place of proximate cause. Second, as I said, it's not applied to any infringing act. Third, it's not being applied to Rhodia's losses, but to Neo's non-infringing sales. Fourth, as at first instance, the legal causation claim doesn't fail simply because my lord has identified catalyst performance as the real driver. On the contrary, 2 additional factors are relied on, as you see from paragraph 118. Those other factors were that the overseas suppliers were later in time and contractually distinct. That's paragraph 112. And that JM chose between Neo and Rhodia based on price and availability. That's 111. Now, it's true that my lord called the first factor the most important of the 3, but nowhere is it suggested that it would have been sufficient on its own. Instead, paragraph 118 contains a statement of conclusion which accords perfectly with the legal test. Taking the 3 factors identified by the judge together, I consider the judge was at least entitled to reach the conclusion that the infringing supplies were not an approximate cause of the losses claimed by Rhodia. So properly understood, the judgment in Neo uses different language to describe 2 different assessments. 1, whether the infringing acts were approximate cause of the patentee's loss, and 2, what it was that drove Neo's non-infringing overseas commercial sales. The decision does not elevate the real driver into a substitute test for legal causation. Before leaving Neo, we should also lance the boil of mistaken counterfactuals. The judge made a clear error on this point, and that Astronics have adopted it in their defence of the appeal. So, for your note, at paragraph 80 of their skeleton, they say that my Lord Justice Arnold treats counterfactual analysis as, quote, a tool used in analysing legal causation. We suggest that's not at all what is happening. This is paragraph 117. And the context for 117 is the ongoing debate at the highest level about the Samco counterfactual. The Samco counterfactual is a forensic tool used to identify the scope of duty in negligence cases, in particular negligence cases about the provision of information or advice. The original example was Lord Hoffman's famous mountaineer's knee. The mountaineer went climbing because he received negligent advice about his knee and sustained an injury in a rockfall. Now, the conventional factual causation counterfactual is what would have happened if the doctor had given competent advice. In other words, if the incident of breach had not occurred. The climber is told his knee is weak, he cancels the climbing expedition and sustains no damage. By contrast, the Samco counterfactual asks what would have happened if the advice had been correct. If his knee had been fine, as he had been told, he would have suffered the same injuries. Lord Hoffman says that points to a conclusion that the injury relates to a risk which is independent of the condition of the knee, and so is outside the scope of the doctor's duty. So the Samco counterfactual can be used to indicate whether the type of loss suffered falls within the advisor's scope of duty. And in NBS and Grant Thornton, the Supreme Court qualified its utility. They said it should not be used to distract from the real question, which was to ask the purpose for which the defendant gave the advice in question. And this is all explained very clearly in paragraph 117 of NEO. In support of their argument on legal causation, Rodeo said, well, look, if NEO hadn't infringed, they wouldn't have obtained any of these overseas orders, which is pretty close to the full factual causation counterfactual, which wasn't even issued by the time of the appeal. But my lord explains at 117 that that's, you say, I do not think that is the correct test in the present context, the present context being legal causation remoteness. My lord then refers to the judgment of majority in NBS, to the effect that counterfactual analysis has been used in negligence information cases, and that in NBS it's said to be a tool that can be used to distinguish loss caused by the information being wrong with loss flowing from the decision to enter the transaction. But then the last two sentences are critical. The SAMCO counterfactual should not replace the decision that needs to be made as to the scope of the duty. You're recording what was said in NBS. As discussed above, the issue in the present case is not as to the scope of duty, but whether the infringing acts were proximate cause of the loss claim. So, pausing there, NBS tells us to be wary of using the SAMCO counterfactual to investigate the scope of duty. There is no issue of scope of duty for patent infringement. It's a strict duty not to commit acts of infringement, as you pointed out, my lord, in your paragraph 48. In NEO, the issue was legal causation and not scope of duty, which is why, if you go back to the beginning of 117, my lord says that counterfactual was not the correct test. It's not the right test for legal causation. So Astronics are wrong to say that NEO treats counterfactual analysis as a tool used in analysing legal causation. It actually stands better for the contrary proposition. Can we then return to the judgment and see what the judge extracted from NEO? This is page 190 of the judgment. Page 334, paragraph 334. He derives 5 propositions or principles from NEO. At this stage, these are said to be applicable to legal causation in the context of damages, but at 352 he says the same principles are applicable to legal causation in account of profits, and he went on to apply them. So it's convenient to consider this as if it were profits. My lord, most of this is the judge's own work. Astronics never argued that propositions 2, 3 or 4 could be extracted from NEO. Let's go straight to proposition 2, which is as follows. It is necessary for the patentee to prove that the infringer was unable to develop, produce or supply a non-infringing alternative, but this is not sufficient by itself to establish that the infringement was a proximate cause. That is a factual causation counterfactual, what would have happened but for the infringement. And we challenge the judge's principle for 3 reasons. First, this simply cannot be extracted from paragraph 116 of NEO. As we've seen in that passage, my lord is not considering the relationship between infringing acts and claimed losses. The reference to NEO's lack of an NIA is in the context of the significance of the cerium oxide to the approval of car makers, one of the interstitial links in a long chain of causation that was an issue in that case. Second, this principle is inconsistent with the whole doctrine of differential profits. The judge had earlier accepted at 325 that Celanese was wrongly decided and that the court should adopt the differential profits approach. That acceptance can't be reconciled with this second principle. It is axiomatic that NIA profits are a legitimate deduction in differential profits. If this principle were correct, it makes no sense. It would mean that at the factual causation stage, the court would decide on the difference between real world and NIA profits, and then at the legal causation stage, the court would find all profits to be too remote wherever it had made a first stage deduction. Third, this principle places an unjustifiable burden on rights holders. The absence of any profit-bearing NIA is unusual. The position of the Lufthansa patent as a gateway to the whole market for Astronics is a true rarity in all the cases we've looked at, and the infringer usually has an alternative route to that market. The snickle chain or the manual method in Siddell and Vickers, the non-infringing slide-in inserts in Abbott, the conventional non-infringing purification step in Celanese. In all these cases, differential profits allows for a nuanced award of a fraction of the profits booked according to the control of the market exerted by the patent. And so too for the trademark cases, lifestyle equities, Cartier and Carlisle, My Kind of Town. There were always alternative marks that the defendants could use. And the question was, well, how much of your profits do you lose? How much of it is due to Chicago pizza? Yet all these cases anticipate that legal causation will be satisfied when the infringer has an NIA. None of them would have satisfied, none of them would have passed the judge's test. Moving on to the third proposition, where the infringement relates to a single component of a complex product, and the infringer has to meet performance standards, not only in relation to that component, but the other components, or the product as a whole, the patentee must demonstrate that the performance of the infringing product was the real driver of the sales in issue. This is a sort of lex specialis applicable to complex products. Again, we say you can't get that from NEO, and we have three reasons. First, it is clear that NEO did not purport to affect any change to the test of legal causation. The real driver is obviously a higher threshold than an approximate cause. It's a test of dominance or preeminence, and in NEO it was common ground that such a test was wrong in law. Indeed, there is binding authority to the contrary. As we've seen, the language of the real driver in 116 of NEO was addressing the causal contributions to NEO's non-infringing overseas commercial sales. It was not being deployed as an alternative test in relation to the link between the original infringing acts, those initial supplies in the UK, and Rhodia's claimed losses. So the judge made a critical error in using it to displace the approximate cause test. Second, there is nothing in NEO to indicate a different approach for complex products. That, of course, is not surprising, because NEO wasn't selling complex products. NEO was selling simple cerium oxide. Third, this proposition is not even consistent with the facts of NEO. NEO was the infringer. NEO sold its cerium oxide to JM, who used it to make catalysts. It was the JM catalysts which had to satisfy the performance standards of the car makers. It's simply wrong to say, as the judge does, that NEO had to meet performance standards in relation to the product as a whole. NEO didn't even know what went into the catalysts. At this point, my lords, can we turn up Astronics' defence of the judgment on this proposition, which is in core bundle tab 4, paragraph 80.
Paragraph.
Core bundle tab 4. I believe it's paragraph 88 of their skeleton. That's mine.
Thank you.
Sorry, that's a bad reference. It's paragraph 81. Yes. Paragraph 81. I think it may be page 81. So the judge's approach here is explained in 4 sentences, and we respectively suggest that they are each wrong. First, we're told that NEO, essentially the lost sales were of complex products. That's not right. The lost sales were of a simple raw material, cerium oxide. Second, we're told that the car makers purchased rival products, quotes, which contained infringing C100N. That's not right either. The car makers purchased catalysts which contained C100N, which had been manufactured in China and never even visited the UK. There were no overseas patents. So even allowing for the solecism of describing a product as infringing, this cerium oxide had never been the subject of an infringing act, never even been alleged to have been the subject of an infringing act. So there is no justification for describing it as infringing C100N. It was non-infringing C100N. Third, they say that legal causation was not established because C100N was not the real driver of the sales. There are 3 problems with this sentence. Problem 1, they're referring to the wrong sales. In NEO, the real driver language was used only once, and that was in the context of NEO's overseas sales, not Rhodia's displaced sales. That's why the judgment in NEO does not link the real driver directly to legal causation. Problem 2. The fact that catalyst performance was the real driver was not of itself enough to establish remoteness in NEO. As we saw, there were 2 additional factors. So the direct link suggested here is also wrong for that reason. Problem 3, again, legal causation is considered in the absence of any associated infringing act. And that's an error repeated in the 4th sentence of paragraph 81, which talks of infringing items. That is, I hope, a convenient moment to develop the point about infringing acts. We've already touched on how under section 80, a patent is infringed exclusively by conduct, infringing acts such as making, disposal, using, and so on. And section 61, which provides for profits derived from the infringement, is a reference to infringing acts. So the court is concerned exclusively with the causative link between infringing acts and profits. That causative link must take in both factual and legal causation. We saw that in Celanese when we looked at it, and in Colby and Palmer, and it runs through the judgment in NEO like the writing in a stick of rock. For both factual and legal causation, if we could just turn that back up. Authorities 3, tab 69, page 2070. Paragraph 22. My Lord reviews a paragraph, a passage from the judge's judgment, first instance, which talks about whether the infringing suppliers were the common sense or proximate cause of the overseas sales. And you say it's clear from the context when the judge is referring to infringing samples and product, she was referring to NEO's infringing acts. But my Lord Justice Arnold is addressing an ambiguity in the judgment, explaining that the judge is correctly directing herself to the consequence of infringing acts. And then at paragraph 50, factual causation is directed expressly to the relationship between claimed losses and infringing acts. As for legal causation, the link to infringing acts is in paragraphs 95, 96, 100, 102, 106, 107 and 108. We looked at 102 already, but just to pick it back up, now we're dealing with this point. My Lord says, it is necessary to consider whether the infringing act is a sufficiently significant driver of the non-infringing sale that it may be regarded as approximate cause. And then the critical conclusion in 118 that the infringing supplies, that is the act of supplying, are not approximate cause. These passages involve the application of the test for legal causation to the statutory tort. There is nothing in any of the cases that suggests that the court can abandon the act-based focus of liability. Yet that is what my learned friends invite this court to do in their written submissions. It is notable that they take a very different approach to factual and legal causation. So if my lords have their written skeleton again, which is 4, bundle, tab 4. Sorry, I have it loose. If we start, please, at paragraph 12. So for factual causation, they toe the conventional line over the page towards the top of page 71. They acknowledge that the but-for test establishes the requisite factual causal link between an infringing event and the loss to the claimant. And at 14, they acknowledge NEO was saying that the question is whether the claimed head of loss would have happened but for the infringing acts. That's the last sentence. And the same point is made in 17. When it comes to legal causation, the position is rather different. So turning back, please, to paragraph 8. When they cite section 61(1)(d), they choose to replace the word infringement, which is used under the statute, with the word invention. Their test is no longer tied to the infringing acts. And that's not simply loose language, because they go on to say in paragraph 8 that the court's approach involves an apportionment of the overall profits according to a fair and reasonable evaluation of the contribution made by the invention to those profits. And at 9, this involves a broad brush evaluation in which the judge has a great deal of latitude to draw on different strands of evidence. One established approach has been to consider the value attributed to the invention in the context of the overall product. And then in paragraph 12, the legal causation, we're told, last sentence, the court must also ask what loss or profits should be attributed to the infringement as a matter of law. Again, this is a broad question of attribution, which is disconnected from the infringing act. Again, in paragraph 19, the question to be asked in any account of profits for patent infringement is similar. How much of the profits, which were the factual consequences of the infringing act and properly be attributed to the use of the invention. So factual causation is linked to the tortious act, but legal causation is untethered. You ask, what can be attributed to the use of the invention? Is it a good invention? Does it appeal to the court? How many marks out of 10? For the reasons we've discussed, that is contrary to neo and contrary to principle. For your notes, there are further examples in 91 and 93, and it's even suggested that our case was that the invention was responsible for all profits, and the footnote is erroneous because in our paragraph 85 of our skeleton we were disciplined in referring to the infringing acts. This same problem is evident in the judgment. It is in proposition 3 itself, where the judge says the patentee must demonstrate that the performance of the infringing component was the real driver of the sales in issue. In other words, there's no such thing as an infringing component, and the relative technical properties and performance of an invention is not an act of infringement of a product claim. And if one turns forward, one can see the problem writ large in the judgment at paragraph 351, subparagraph 3, where the judge says this.
Sorry, 351.
351, paragraph 3, so that's page 205. So this is addressing an issue on convoy goods. And the judge says, I can see no reason of logic or principle why a different test should apply to the question whether the profit on the entire article was derived from the infringement, and the question whether the profit on the convoy goods was derived from the infringement. In other words, the reason is that the disposal of what the judge calls the entire article was an act of infringement under section 60, whereas the disposal of a convoy good was not. The 1977 Act provides that remedies, damages and profits must be made available for the former, and it makes no provision for the latter. The distinction could not be more fundamental. And as one might expect, the judge's approach here gives rise to corresponding errors when he came to apply these propositions to the facts. The last proposition from the judge is proposition 4. So this is back on page 191. He says, in order to determine whether the infringement is a proximate cause of the relevant losses, it is not enough simply to consider the counterfactual in which the infringer did not make the infringing supplies, although this may be a useful cross-check. See Neo 117. Well, once again, that proposition can't be taken from Neo. We've looked at this already. Neo 117 addresses the Samco counterfactual and not the but-for factual causation counterfactual. And indeed, my lord says it's nothing to do with legal causation remoteness. So 117 is properly an authority against allowing a counterfactual to do legal causation work. At least if your legal causation test is a proximate cause. My lords, for these reasons we respectfully submit that the learned judge made a host of errors regarding legal causation, and we now come to the most fundamental disagreement we have with the judge on this issue. It is our position that legal causation remoteness serves the same objective for damages and profits. That objective is to sever over long chains of causation. So the acts of infringement are not a proximate cause of damages or profits. Those damages or profits are not recoverable. The question, was a tortious act a proximate cause of the loss or profit, invites a yes or no answer. The profits or damages either are or are not too remote. The chain of causation tolls until it breaks. If remoteness is established, there is no consolation prize. The court does not say your losses are too remote, so you only get 40% of them. That would be an unprecedented and unprincipled outcome that was with the very language of causation. And yet that is the outcome in the judgment. The judge didn't make a partial rejection of Lufthansa's claim in respect of legal causation. He held that the entirety of the profits sought were too remote. And we can see that in several places. Could we start at 352, please? The judge says that in determining whether the test for legal causation is satisfied, the judge should apply the 5 propositions that we've just been looking at. At 353, he says that what he calls the NEO test applies to profits on secondary components and ancillary goods and services. So what the judge calls the NEO test applies to everything in issue. And then at 467, which is page 261, in the last sentence, he says that the gateway status of the patent is not sufficient to establish legal causation, and I hold that the infringement of the patent by Astronics was not the legal or proximate cause of the profits in issue. At 469, he observed that Lufthansa's claim was to a single indivisible pool of profits, and that he might have reached a different conclusion if the claim had been advanced to a smaller pool of profits. He might have done, but he did not. And then turning back, please, turning forward to page 386. There's a section where he set out his conclusions. In conclusion 8, the infringing dealings were the factual cause of the profit on relevant transactions, but not the legal cause. And conclusion 9, I have found that for each of the defendants, none of the profits in A, B, C or D, so that's covering primary components and secondaries, etc., none of the profits were legally caused by the infringing dealings. That is an express finding that sales of the primary components, the actual power supplies, were too remote from the profits achieved on those sales to give rise to an award. Too remote from delivery. The sales, the infringing act was the delivery of the product, but the sale was too remote from the delivery for profit to be recovered. It's a point I'm going to come back to when we look at the application of the test to the facts. But we think this rather strange outcome may be the result of the judge seeking to marry up the two inconsistent lines of authority I mentioned at the outset. The modern approach of factual and legal causation, where factual causation does the isolation work, nuanced 0 to 100%, and then legal causation severs any overlong chains. To marry that up with the older United Horseshoe and Celanese approach, where that first profit isolation step is not permitted, and instead causation is dealt with holistically, factual and legal causation all lumped in together under a broad allocative exercise. Neo is a modern case. It splits causation into factual and legal. And the judge may have been attracted by the apparently common references to real driver in Neo and driving the sale in Abbott, and sought to produce a universal theory of profit causation. We can't be sure because there was no argument or discussion about it. If that was the intention, we suggest it hasn't worked. Because in the modern two-tiered approach, legal causation is a binary tool, and that is the position throughout the law of tort.
So the logic of your argument is the judge should have awarded you nothing on the basis of his finding that there was no legal causation.
If I accepted his application, well, subject.
Well, I follow you don't accept he was right in that conclusion, but simply as in terms of structure.
Yes, absolutely right.
Having found that the profits were factually caused by the infringing acts, but not legally caused, the answer should have been you got nothing.
Had to be nothing. There's no warrant for awarding profits or damages which are too remote from a breach. That's the purpose of the doctrine of remoteness. We were the wrong side. The chain had broken. According to him, we were like the defendants the claimants in Rukadza chasing after the investment income. It's off in the distance. You're too remote. You don't get a percentage of it as a consolation prize. It wasn't legally caused. That's it. It's over. Now, there are two important reservations about that, as you would expect. The first is, as we've seen, he's got the wrong test. The real driver is a test of dominance. And secondly, as we'll come on to shortly, in his application of that test, even that test to the facts, he's made a series of errors. My learned friends advance two defences of the judge's approach. The first is they say, oh, well, it's just shorthand for saying Lufthansa hasn't met the threshold for claiming all the profits. But that's clear, contrary to clear express wording we've just been looking at. The judge couldn't have been clearer. None of them is caused. Second, they reason by reference to reasonable royalties in the law of damages, licence fee damages. This is my learned friend's paragraph 86, and this is the last point I want to cover on ground 2. That's page 89 of the core bundle. You could read that, please.
Paragraph 86.
Paragraph 86. So the first error here is the elision of a proximate cause with driving the sale, which we've already discussed. But more fundamentally, the analogy between profits and licence fee damages is misconceived, we say. Let's start with damages. If a patentee fails to prove legal causation of subjective lost profit damages, the loss they actually personally sustain, they receive 0 lost profit damages. But they can still obtain objective licence fee damages or reasonable royalties. But that outcome is the result of a specific line of authority, which makes such awards available in the absence of proof of subjective lost profit. In such cases, the law deems there to have been a lost licensing opportunity. The chain of causation for licence fee damages is very short. Unlicensed infringing act, lost licence opportunity, reasonable licence fee. The notional licence fee is not too remote from the acts of infringement. It is definitively not an award of a sum which is not legally caused by the infringement. For profits, there is no equivalent backup. There's no doctrine of objective user profits or licence fee profits. The claimant takes the infringer as he finds them. So there is no juridical basis for a consolation prize licence fee. Any profit made by the infringer which was remote from the actual breach is irrecoverable. And that is why in Lufthansa, the ex-directors were permitted to keep all their investment profits. The profits cases involve awards by reference, the profits cases which do involve awards by reference to licence agreements are not decided within and do not purport to apply the modern factual legal causation framework. There is no indication in any of them that the remoteness test has been failed. Instead, causation is dealt with holistically and given effect by way of a broad allocation, as happened in the Appellant case. But those provide no support for the judge's award of profits where the profits were too remote. My lords, that's ground 2, and I was going to move on to ground 3, which is an independent ground of appeal. We say it can and should succeed, even if the judge was right to endorse a double deduction approach and right to apply the real driver as the test for remoteness. Even if he was right that legal causation was apt to give effect to a division of profits. In the judgment of paragraph 351, we were just looking at that. He said that the challenge for Lufthansa was to establish that the infringement drove Astronics sales. And we say, if one stands back for a moment, one can see something has gone very wrong here. The defendants made profits by selling Empower Systems products. The infringement was the supply of those products in the UK, and the judge has held that the profits made from selling those products were too remote from the acts of supply to be recoverable. That is, we suggest, an obviously unsustainable conclusion. It is therefore not surprising that the judge made a series of errors in reaching it, and we rely on 5 of them. First, he did not address remoteness by reference to wrongful acts, infringing acts. Second, he relied on the relative success of KID and Astronics when that was logically irrelevant. Third, he relied on Astronics' power management patents and power management technology when he previously refused Astronics permission to amend to plead them on causation. Fourthly, he relied on unpleaded regulatory and safety features without reference to the unchallenged contrary evidence. And fifthly, he misunderstood the trade that was an issue for Astronics.
So what was the last one?
He misunderstood the Astronics trade in issue. He didn't understand what it was that Astronics was doing when he reached his conclusions. They were selling only to the power-only side of the market. So I'll take them in that order. And the first one is the most fundamental error. The judge lost sight of the wording of the statute, and that led him to embark on a multifactorial analysis, which is no application to the facts of this case. So under error 1, we're not challenging that analysis, we're challenging his decision to do it at all. When we discussed ground 2, I explained our position that the test for legal causation must be applied to infringing acts, and that those acts are the supply in the UK of primary components. That's the in-seat power supply, the outlet unit, and the cable that goes between one and the other. The outlet unit, that's the one you actually plug your laptop into. And if you take the core bundle at paragraph 55, sorry, page 55 of our appeal skeleton, you will see under paragraph 79 an excerpt from a typical Astronics offer document. This one was for Air China. And the document opens, they're not there, with the words, Astronics is pleased to provide this proposal for the mPower 110 volt AC passenger in-seat power system. And this offer includes in the very first row 15 in-seat power supplies for $16,140. And in the 6th row, there are 30 outlet units for $6,090. 4th row, there are 30 cables joining the two for $8,000. These sales took place pursuant to this offer document, and Astronics realised their profit margin on them. The act of supply was the supply, the act of infringement was the supply of these products. The infringing act is the revenue generating transaction. There are no intervening links, no third party decision points. The consideration is paid for the very act that constitutes infringement. It is not simply that the chain is short. There is no chain. It was wrong in principle to carry out an assessment of chain length measurements in those circumstances.
This shows, does it, that the unit price for the patented components is $1,000 odd.
So, yes.
But if they supply a seat,
they don't supply a seat.
right? I think
the point I'm making. This took place.
Yeah.
They agree this price. The products get delivered to Air China's agent in the UK. That is an act of infringement. Air China send the money back. So thank you for sending the products. And the judge has said that money is too remote.
No, I follow.
From
but
that
is it not a way of isolating the profit attributable to the patented product, the supplier of the patented product?
It is what a method of isolation?
This kind of document. I think what you're saying is that the ISPS consists only of your patented product.
So at the moment I'm dealing with, there are primary components which you put together to make the power supply that infringes.
And that's the ISPS.
And that's what I'm showing you here. Those primary components, these are the three parts of the system that put the patent into practice, and it is an infringing act to supply them to a third party in the UK. That is what happened here. In consideration for that supply, money was sent to Astronics, they made their profit margin, and the judge said, too remote.
Yeah.
How did he reach that conclusion? Well, the judgment deals with legal causation on the facts at great length between pages 208 and 264 and the analysis is completely disconnected from the concept of infringing acts. For present purposes, we can demonstrate the sorry, my claim.
Claim that was infringed.
Yes. Yes. So do we have the claim somewhere? Yes, I'm sure it's in the judgment, but it was common ground at the account that the acts of infringement, well, I think it's recorded in the order at first instance actually, that the acts of infringement were the supplies of what are called the primary components. So that little excerpt shows you the three primary components. It was common ground that constitutes an act of infringement.
I was suggesting it was common ground. The times of ISDS fell within the claim. So my understanding at the moment is that that's not correct. Rather, the ISPS incorporated the three components that fell within the claim.
Well, my lord, I answer that question by reference to infringing acts and not infringing components. It was an act of infringement.
You only infringe by supplying that which is within the claim. You don't infringe by supplying that which falls outside the claim.
Indeed.
And what we are concerned with here, as I understand it at the moment, is a situation where there is an assembly, some of the components within that assembly fall within the claim, other components within that assembly do not fall. This, therefore, is the crux of the problem. Because you may be entirely correct to say that commercially it's one article, but nevertheless it is an assembly of components that fall within the claim and components that don't fall within the claim. And you're right that the act is what infringes is the act of supply, but it only infringes if and to the extent that what is supplied is a product within the claim. So the two are in fact indissociable.
So the
claim, incidentally, is at page 71.
yes, the claim is at page 71. Yes.
And there's a bit of a specification quoted just before that.
So yes, so claim under paragraph 129, the judge sets out claim one of the patent which was infringed in the UK.
Yeah. So socket comprising socket detector, etc.
Yes. So those were the components, the primary components. So I was going to demonstrate what I say was the judge's error in forgetting about the nature of the wrongful act by reference to paragraph 467.
467.
467, which is on page 261 of the judgment. So the heading is legal or proximate causation, and in the third line of 467 the judge says the critical issue is whether the infringement was the legal or proximate cause of the profits in issue. And if you look at subparagraph 1, he considers Astronics' use of two of the features of claim 1 to obtain certification from the regulators. And then at subparagraph 2, he considers the use of sub-features of claim 1 to obtain Boeing and Airbus approval. So that is abstracted from the infringing act. Applying for and achieving certification and approval, these are not infringing acts. These steps occurred before any infringing acts of supply whatsoever. The statutory tort consists of supply, and the profit was earned in consideration for that supply. And nowhere in the whole section does the judge consider the causal role of that act of supply in the accrual of profits in issue. Moving on to the second error, in his decision on remoteness on the facts, the judge placed heavy emphasis on the fact that the Astronics product was far more commercially successful than the KID product. In that paragraph 467, he gives 9 reasons why Lufthansa failed on legal causation, and this point made up 3 of them. The discussion runs from paragraphs 402 to 425. The position was this: there was no dispute at trial about the sales figures. Astronics sold a lot more than KID, and Astronics attributed their success to factors such as the lighter product and better after-sales service. For the purposes of this appeal, we can accept that explanation. So the position was this: 2 competing products in the mains voltage AC power market, both using the patented invention, one outperforming the other in that market for reasons unrelated to the patents. Our submission was that these 2 data points, the sales of Astronics and the sales of KID, provide no information about the causal importance of the patent. And the reason for that is straightforward. Both data points relate to products using the invention. The invention is therefore a constant and not a variable. To assess the significance of the invention, one needs to compare the performance of a product which uses it with the performance of one that does not. Where the presence of the invention is a constant, the comparison provides no logical evidential basis for assessing its causal contribution to Astronics' profits. We do accept that the judge was entitled to draw broad brush inferences in assessing proximate cause or the real driver of sales, if that was the right test. But even a broad brush inference must be logically available on the evidence, and here it was not. Let me see if I can assist with an example. Suppose I have a patent for a 4-wheeled motor vehicle. My licensee is Fiat, and the defendant is Volkswagen. Volkswagen sells 10 times as many cars as Fiat, and they say that their superior sales record is due to brand reputation, reliability, dealer network, resale value, and it has witnesses lined up to say so. This may all be true, but it tells us nothing about the importance of the patented feature, 4 wheels. If you ask consumers why they bought their cars, no one would say, oh, it's because it's got 4 wheels. But no one's buying 3-wheeled cars. In order for any comparison to be drawn between my 4-wheeled patent and other factors, one needs data for sales where the invention is absent, what a scientist would call a controlled experiment. In this example, that would mean comparing Volkswagen selling 4 wheels with Volkswagen selling 3-wheeled cars. At the very least, you would need information from which you could infer sales or performance of 3-wheeled cars. But relative sales between 4-wheel Volkswagen and 4-wheel Fiat cars provide no indication, as a matter of logic, of the causal significance of having 4 wheels. If one follows the judge's logic, the sales differential between Volkswagen and Fiat can be said to prove that a good dealer network is more important than having four wheels. In fact, the judge's error here is worse because he had the outcome of a relevant control experiment to hand. He had a factual finding of how successful Astronics would have been if it avoided the patent. How many sales it would have made. That is the conclusion he reaches at paragraph 304 of the judgment.
304.
304. I reject the defendant's counterfactual that they would have been able to market and develop a non-infringing alternative to the 12XX series. In other words, if they didn't use our invention, they would have made no sales. Zero. Now, once the judge adopted the real driver as his test for legal causation, the causal potency of this factual causation answer became directly relevant. That finding at 3 or 4 is the clearest possible evidence of the causal potency of the patent, and the judge left it out of account entirely. Let me show you that now. If you move forward, please, to paragraph 402. This is page 230. 232. So the judge introduces the point at 402. He notes that both Astronics and Kidd were using the invented features throughout the relevant period, and that Astronics outsold Kidd. And then at 403, he frames the question. He says, one conclusion which can be drawn from the relative performance of Astronics and Kidd during the relevant period is that they were the two major players in the ISPSS market, and that without the features of the patent, neither could have competed at all. Lufthansa invited me to draw this conclusion. Pausing there, by this point in his judgment, that is no longer a matter for debate. When the judge concluded that Astronics had no non-infringing route to market, that was a factual finding that without the patent, they could not compete. He then continues, the alternative was that Astronics' greater success in the market can only be explained by other factors, since there was a level playing field throughout the relevant period, and both were able to make use of the inventive features of patents. In my judgment, the choice between these two conclusions can only be addressed by considering the evidence as a whole. My lords, that is not a logically or evidentially alternative conclusion. Both conclusions can exist, indeed, in this case, they do. Both firms needed the patent in order to be in the market at all, and Astronics outsold Kidd for other commercial reasons. The judge's approach in setting these up as alternatives is logically flawed. And if you turn forward then to 416, where he starts his findings on this issue. He records the difference in performance between the two rival exploiters of the patent. And then at 418, he says this: if Astronics had undercut Kidd in price and outsold it by a few thousand units, I might well have accepted Lufthansa's argument that Astronics was unable to compete in the market at all without infringing the patent. the whole premise for his assessment of legal causation is inconsistent with his factual findings on factual causation. This was not an argument he was free to reject. It was established as a fact that Astronics was unable to compete in the market, and he's completely disregarded that. And then he continues, in my judgment, however, the infringement of the patent cannot explain why Astronics outsold Kidd by a factor of 10. Well, with respect, that imposes an impossible challenge. The patent can't explain the difference in sales between Astronics and Kidd because they were both using it. The patent is a constant and cannot provide a justification for the sales differential. So the judge has made two fundamental errors of principle in his reasoning on this key issue. First, he treated the sales differential as informative of the causal potency of the patent. And second, he ignored his own NIA finding. The NIA finding properly demonstrated that the patent was a complete barrier to the market for Astronics, and there was no other evidence before the court on which the judge could properly attribute anything like that level of causal significance. It is only by somehow ruling it out that he could even embark on this exercise. And also that's error 2, and error 3 relates to power management. And this turns on the judge's prior judgment of 25th July 2024. And we need to look, I'm afraid, with a bit of care at the pleadings, because our complaint here is that the judge upheld the case which he had expressly excluded from the trial. We accept that Astronics had pleaded power management in respect of apportionment. They argue that the profit should be divided up by reference to the proportion of components which the patented features directly comprised. They relied on power management as part of that case. They also included their power management patents as part of a patent counting apportionment case which was never pursued. But power management formed no part of their pleaded case on causation and no part of their pleaded case on legal causation remoteness. But in the summer of 2024, a few short months before the trial, they sought to do a wholesale reworking of their position on causation, and as part of that they wanted power management to play a prominent role. They said their power management technology was the key technical barrier to providing an in-seat power supply system, and they wanted to rely on their patents in support of it. We resisted those amendments, and the application came before Mr. Justice Leach in July 2024. His judgment, no, we need to start with the defence first, which is the core bundle, paragraph 26. Tab 26. He held that the causation case on power management was a new case which Lufthansa had not had an opportunity to meet. He refused permission to include it. And in the judgment under appeal.
Sorry, just a minute. Tab 26.
Tab 26. I'm going to take you to the pleadings.
Re-amended points of defence.
Yes, so I'm going to take you to the pleadings first before the judgment.
I follow, but was this a draft or as, I mean, it says at the top, re-amended pursuant to the order of Mr. Justice Leach.
Yes. So
we're looking at a pleading that.
So there were a couple of tweaks which were uncontroversial, but this does not include any of the amendments which he ruled out.
Right.
So my lord is right, but it doesn't matter for present purposes.
All right.
You can take this as, in effect, the pleading as it stood before the application to amend and after.
Right.
I think that's right. I'll correct myself as I go. So yes, anything you see in purple was added after the amendment application, but all the green text was already in.
Yeah.
Could we start, please, at paragraph 21? On page 393, where apportionment begins. And this is apportionment by reference to components, and it's split into two sections, functional and commercial non-essentiality. And we start with functional non-essentiality at 23A, and we're told that the mPower systems had various functions in addition to AC power. And 23A1 is power management, where configured with an MCU. That's a master control unit, and it is actually the master control unit which achieves the power management objective by directing the behaviour of the individual passenger power supplies. It's actually, the MCU is optional, but it's installed in most systems. And 23B refers to mPower systems having various safety features in addition to the invention. And those include such prosaic matters as on-off switches and warning labels. And 23C sets out the applicable regulatory requirements. First in the US, that's FAA, and then in Europe, that's EASA. And that's all in service of the plea at 23D. But there were various other ways in which mains AC power could have been delivered. This is not at this point a plea of causation in respect of these alternative systems, in particular not a counterfactual plea. If you just flip forward to page 399, 23FA, you'll see that these are relied upon in support of apportionment. So everything up to this point relates to apportionment. And then at 23G, there's a second heading, commercial non-essentiality. This is divided into in-flight entertainment, IFE sales, and power-only sales, with 23H. You see that division, and then we're told firstly about IFE sales, the factors which drove the customer's purchasing decisions, price and touchscreen technology and so on. At present, we're only concerned with Astronics, so that's 23J on page 401. And we're told the factors are price and after-sales service and weight and so on. 23K is then KID versus Astronics, which we've just addressed. 23L is a bit of an oddity. There's an insofar as plea in respect of certification being relevant to customers' purchasing decisions, and I'll come back to that. And then over the page at 24A, we have patent counting that was abandoned at trial. And then 24B, there's a broad sweep up apportionment. Everything we've just looked at, functional, safety, regulatory, commercial factors. 25 is important for present purposes. This is the legal causation remoteness plea. And it expressly calls out 17 to 17S in paragraphs 23G to L above. That's the commercial non-essentiality points. It is careful to avoid cross-referring to the technical issues. So nothing about power management, safety, regulation. That's not the entirety of the causation plea, because you please turn back now to 17C on page 388. This is the response to Lufthansa's assertion that the infringing dealings drove the relevant transactions, with relevant transactions including convoy goods and services. And this is the paragraph which Astronics sought to extend in their amendment application. They wanted to introduce a positive case as to what drove the profits in issue, which was precisely the issue that the judge is addressing under our ground 3. And if you look, please, at the final 4 lines, there's another little bit of legal causation there, which had been introduced by a prior amendment. It said here, certification was not a proximate cause of the decision by third parties to purchase the primary components. That is why 23L was an oddity. It relied on certification insofar as it was of interest to customers. But Astronics' primary case, as pleaded here, was that certification was not of interest. And then we saw the positive case that those decisions, the customer decisions, were driven by the commercial non-essential factors in 23I to J. So the position on the pleadings was this. In respect of apportionment, factors relating to function, safety, certification, and commercial purchasing decisions, they all matter. In relation to causation, including legal causation, Astronics relied on commercial decisions. And in that context, can we go to the judgment on the amendment application, which is in the supplemental bundle, tab 8. Tab 7. No, sorry, it is tab 8. As you were. Is that right? Yeah. So,
Judgment of the 25th of July 24.
my lord, yes. Could we pick it up, please, at page 65, paragraph 32, where the judge records that Astronics proposed to introduce an allegation that the key technical barrier to entry to the market was not a power supply design, which was safe and robust, but instead power management architecture. And then the whole of that quote is the proposed amended pleading. And if you go to sub-paragraph A, that sets up power management as overcoming a key technical barrier. And then sub B seeks to introduce safety factors as a causation issue. They are being elevated to a response to the infringing acts drove the profits plea. And in sub C, so are regulatory factors. So this is a wholesale attempt to repurpose the technically non-essential features, which are there for apportionment, as a causation case. And this is all going to be refused. Turn forward to paragraph 36, please. This is within the commercial section, and there was a proposal to add the words, including requirements for power management, there. So what it said at the moment was offerability by Airbus and or Boeing, and they wanted expressly to include power management as part of that plea. Now, our position was, we don't think this is a good apportionment case. We think this is about differential profits. So we take a different view on causation issues, which we consider to be really important, and apportionment issues, which we consider to be less important. And that was explained in learned instructing solicitors' evidence, which the judge quotes paragraph 41 on page 70. That that explains that the objection is to the repositioning of this issue as a defence to Lufthansa's case on causation. And over the page at lines 6 to 12, Lufthansa's position that causation is much more significant. That is precisely what we had already told the court when obtaining the order from Sir Anthony Mann, which obliged the defendants to plead out any NIA case. Anyway, we said a different disclosure regime would have been sought if these new matters had been pleaded for causation from the outset. And at paragraph 69 of the witness statement that's quoted there, there are some specific points made about reliance on power management patents. Mr. McCulloch says if these had been pleaded for causation, we'd have investigated their validity. And that stands to reason. The patent in suit had been subject to a sustained validity challenge at first instance and on appeal. No one had even looked at the Astronics patents. They'd never been mentioned in this context. But if they were going to be said to have a causal status which equalled or exceeded that of the patents in suit, well, we'd want to scrutinise their validity. Can we turn forward, please, to 84, where the judge gives his conclusions. He starts his conclusions about power management. In the second sentence, he records Astronics' submission that the new causation case in paragraph 17c(a) gave rise to exactly the same issues as the existing apportionment case.
Yeah.
Note the acceptance by Astronics that this was a new causation case, but they defended its inclusion because it reflected the existing apportionment case. But in the last sentence, the judge rejects that submission and gives his reasons in the subparagraphs following. In 84.1,
Do we need to go through these reasons in any detail? I mean, we know he rejected it. Your complaint is that he allowed it to be run despite his rejection of the amendment.
we do need to look at them, not in great detail, but because it shines a light on the distinction which he then doesn't carry through.
All right.
So, at sub 1, he adopts my submission that they had chosen not to rely on any of these particulars as a defence to causation and relied only on the particulars of commercial non-essentiality. He says it was reasonable for Lufthansa to assume they were not advancing any positive defence to causation in reliance on the MCU or AMCU. That is a reference to power management. We've just looked at this. Functional non-essentiality, solely an apportionment plea. Commercial non-essentiality does double duty and is expressly cross-referred. And the judge says that functional non-essentiality, the MCU and the MCU, nothing to do with causation. And when he says so picking it up 4 lines down, yes, Astronics chose not to rely on any of these particulars of defence causation. He refers to the last sentence of paragraph 17c. That was the forward cross-reference we looked at, which said such decisions were driven by the considerations in paragraphs 23i to j, the commercial non-essentiality. The judge could also have referred to the legal causation remoteness plea, which we just looked at in paragraph 25. As to the reference to the MCU and the AMCU, that is a shorthand for reliance on power management. as you can see from paragraph, if you just turn the next paragraph, paragraph 84.2, because the judge said the same point could be made in respect of 23D, which is certification, and he says this, that the existing pleading would not have put Lufthansa and its team on notice that the defendants intended to plead that their power management architecture overcame the key technical barrier. So power management architecture is synonymous with MCU or AMCU. Sub 4, he then deals expressly with the offerability by Airbus or Boeing, the sort of Trojan horse argument. Astronics said that Airbus and Boeing required power management, so offerability by Boeing was a reference to power management, and he rejects that argument and does not allow the amendment to expressly refer. At 86, he records our submission that this evidence introduced a case which we would only be able to meet by investigating the validity of the patents. And 87, he said, well, he records how Astronics dropped the reference to the patents in an attempt to try and get the new case in. And he explains there, correctly, that the new causation case doesn't work without patents because the power management technology would simply be free to air. Everyone could use it. So it needed the patents, which by this stage they'd already dropped. Lastly, 88.3 on page 99. Could you read that yourselves, please?
Yes.
So can I sum up where we are after this judgment? Astronics had pleaded power management for apportionment in relation to functional non-essentiality. That case didn't refer to any patents. The case on legal causation relied only on commercial non-essentiality, and they chose not to rely on any functional issues, which included power management. At the hearing, they sought to introduce a new factual and legal causation case based on power management, safety and regulations. The new case relied on patents, but they dropped them at the hearing, and the whole thing was thrown out. Permission was refused because Lufthansa had not had warning of the new case, but did not sought to meet it in evidence or sought disclosure in relation to it. We can put that away and see how this plays out in the judgment. Starting please at paragraph 389. Paragraph 389 is far too narrow. While it's right that the July judgment refused permission in relation to a plea relating to the technical barrier to entry to the market, it did so because it was a causation plea. As we've seen, the ratio of that decision was that it was not fair to Lufthansa for Astronics to move what was just an apportionment point over to causation. That's precisely what he said in paragraph 84.1 of that judgment. And that overly narrow reflection of the July judgment then feeds into paragraph 390, where the judge effectively decides to take the opposite course. He allows reliance on power management in relation to legal causation. He says that's permissible because they pleaded it in relation to apportionment. But this isn't the section of his judgment about apportionment. We're in legal causation, which on his approach determines whether you even get to apportionment. This is precisely the more important issue that we were worried about. and it's precisely the basis upon which the amendments were refused. And if my lords turn forward to the conclusions in paragraph 467,
Sorry, which one?
page 262, please. And this is 467 sub 4. He decides, in the context of legal causation, that power management was functionally and commercially essential. And that Astronics power management function systems drove the sales of the mPower system just as much as the infringement of the patent. My lords, as we saw, the power management amendment, which the judge had refused, was a response to Lufthansa's plea about infringing acts driving the sales. They sought to introduce it both through functional and commercial non-essentiality, and both routes for causation were refused. In this conclusion, both routes have been upheld. There is no distinction between this conclusion and the pleaded case, the proposed amended pleaded case, which he'd excluded. And that just leaves the patent point. How does this work without patents? In his account judgment, the judge accepted that Astronics can't rely on power management patents. What he's missed here is the inevitable consequence of that handicap, a consequence he was alive to in July. The technology disclosed in these patents is necessarily put into the public domain in a manner that enables everyone to use it. So without the associated monopoly, without the patent, any competitor was free to implement it. We recognise that at paragraph 87 of his July judgment. Without the protection of the patent, power management couldn't possibly be responsible for driving sales preferentially to one company or another. Indeed, the judge's language at 390, turning back please, demonstrates the strength of this point. He says, in the middle of the paragraph, Astronics were entitled to argue that their own invention was of equal, if not greater, commercial significance as Lufthansa's invention. Invention because it's the subject of a patent, but they were never allowed to say that. That is an acknowledgement that without the patents, the argument simply doesn't work. Error 4 is not unrelated. Regulatory and safety features. The judge placed heavy reliance in his remoteness decision on regulatory and safety features, and as we saw when we put through the pleading, these matters were pleaded under functional non-essentiality. They formed no part of the legal causation or causation plea. They're not cross-referenced in paragraph 17c of the pleading or in paragraph 25. And in addition, we saw that in July 2024, Astronics applied to amend to introduce them into paragraph 17c, and that application was refused. But in addition to not being pleaded, these factors are irrelevant to causation. Astronics was right not to plead. Their irrelevance it's a matter of economic logic, which in the context of the safety features was also confirmed in evidence. And let me deal with the evidence briefly. We looked already, you don't have to turn it up, at the points of defence. As part of the apportionment case, Astronics had a shopping list of safety features. On-off controls from the flight crew, warning labels, ground fault protection, and so on. There's a whole host of them. They never pleaded that compliance with these features involved any technical challenge, and they led no evidence to that end. So there was nothing to distinguish a ground fault interrupt from a warning label. But out of an abundance of caution, we invited our technical expert, Professor Wheeler, to go all the way through the pleaded features. He did so. He gave evidence that including those features in a power supply at the relevant date involved no technical difficulty whatsoever. He said this sort of power supply, quote, will always need to be designed to incorporate standard safety features and avoid common hazards associated with high voltage electrical power. He said the features were all technically trite, and his evidence was unchallenged. It's paragraphs, pages 5 to 9 of the supplementary bundle for this appeal. So on the facts, it was common ground that the pleaded safety features were trite and readily available to anyone in the marketplace to implement. As for regulatory approval, while there was evidence that it represented a significant bureaucratic challenge, there was no plea and no evidence of any technical difficulty in achieving compliance. So, in that context, how could these matters be relevant to the profits in issue? The court was concerned with the factors which drove sales. That must mean factors which conveyed a competitive advantage in the market. Regulatory approval, which includes mandatory safety features, is a requirement for presence on the market. It determines whether a product may be sold. It's axiomatic that every supplier must satisfy a mandatory regulatory regime, and it therefore follows that compliance per se does not confer a competitive market advantage. It simply allows participation. Consider the regulatory requirements associated with motor vehicles. They include safety features like tyre tread depth and toughened windscreen glass. There's no technical difficulty in complying with those requirements, and all vehicle manufacturers do so. And achieving compliance doesn't give a competitive advantage. No one chooses to buy a car by reference to its tyre tread. That's not to say that the means of compliance cannot be advantageous. One can conceive of a solution which is particularly cheap or effective or even attractive to customers. But that's a feature of the solution and not mere compliance. No case about solutions was ever advanced. And we say we saw this effectively correctly acknowledged in the two-stage approach taken in Astronics' pleaded case. Their causation plea related to customer preference factors, price, weight, reliability, after-sales service. Nothing about safety or regulations. So I wonder if that's a convenient
Yes, two questions. How are we doing for time?
I'm pretty close to the end of ground 3.
Right.
10 minutes.
We're not holding you necessarily to the 2 days for this appeal, but you are going to be held to 2 days overall. So if you use up more on this appeal, you will get less on the remaining appeals.
I'm aware the sands of time are running.
Yes. All right. Second question. I see that there are transcribers. Are we going to be provided with a transcript overnight?
No doubt that will happen, and we will make sure it does.
Thank you very much. 10:30 tomorrow.
Yes, please. Thank you.
Yeah, yeah.
You can take roll because we've been excused. Two. Hugo's kit.
This is the one going out tonight. I mean, like, don't get me wrong, it's a pretty dashing look, but it's just not the weather.
Just get rid of it. Shall we consult? Take that. Top one, please. Are you in that?
Well, not, I mean, it's close to my hand.
It's easier to carry them. Are you wanting this one? I think it was over for us.
Yeah.
Are we taking all of Chris's stuff?
Yeah.
Pop that in it, and then what I'll do is I'll leave this in chambers again and get Harry to.
Did you leave it in chambers?
Harry,
I sent an
ran.
email to chambers.
Yes, I don't know if someone met him halfway because he was really, really quick. He was like 4 minutes or something. But I think he might have run.
Did you do a relay?
Yeah, that's normal.
I'm a flurry, he likes your flurry. Flying throughout.
It'd be nice, wouldn't it?
And then
It's not going to get any cold.
No, I've understood that to be the case. Yeah. Sent my kit back. Right. I'll make my apologies. I think we will just stand up tomorrow without walking.
Okay, I'm very happy to do that.
That's right. They'll just stay down.
Yeah.
I think you'll grow
Railway tracks, yeah.
Yeah.
Please, yeah. Do you want to? I mean, I'll tell you one thing I would. What I would like to see.
Go back.
And go on the chat. Yeah. No, you.
I'll just be in
there. Yeah.
Second, yeah.
So
I want to do it.
why don't you say typo? Yeah, I mean, I think
find that. I'm sure I find that.
Yeah, so these,
I know.
these in. Oh, perfect, thank you.
The only one that's reminded me. Good. Okay, hold on. It's the point. Yeah, no, that's I think that was it. Let's just go. both of them. That should continue.
And then on a different travel movement. You okay? How are you?
I know it's a bit hard to be doing this, isn't it?
You see that white box at the end? Are we okay to move stuff in the corner?
Yeah, it would be
Oh,
lovely.
perfect, thank you. Just thought it's good to double check, 'cause it's the one time you don't check that it's then like not okay.